Welcome to the ACEDS webinar channel. Happy Monday, everybody. I have been so excited and looking forward to introducing our guest speaker and great friend, Shawn Tuma, today for our Cyber Monday webinar, Yours, Mine, Ours, Protecting the Data Gathered and Exchanged in Litigation. I'm Kaylee Wallstad, Director of Strategic Partnerships for ACEDS, and this week we'll be addressing the Wells Fargo data breach incident, which I'm sure all of you have seen and heard about. There's just been a lot of discussion with two webinars this week. One will be the webinar which you're on right now, as well as our Wednesday, August 9th at 1 p.m. We'll have Kelly Twigger on discussing how to avoid your own Wells Fargo moment. And at the end of this, toward the end of this webinar, we'll have a link for you to register if you are so inclined. Again today, we welcome our great friend Shawn Tuma, who is just fantastic. Shawn Tuma is an attorney internationally recognized in cybersecurity, computer fraud, and data privacy law, areas in which he practiced for nearly 2 decades. He's a partner at Sheep & Stone, where he regularly serves as cybersecurity counsel, advising a wide variety of businesses ranging from small to Fortune 100 enterprises, to being called before Congress for expert opinion on potential cybersecurity legislation. We're very fortunate to have Shawn here. In 2016, Shawn was selected by the National Law Journal as a cybersecurity law trailblazer and Texas super lawyer for the top 100 lawyers in Dallas-Fort Worth. He is regularly selected for D Magazine's Best Lawyers in Dallas and Texas Super Lawyers. He also serves as general counsel and board member of the Cyber Future Foundation, on the Policy Council for the National Technology Security Coalition, Cybersecurity Task Force for the Intelligent Transportation Society of America, and the advisory board of the University of North Texas Cyber Forensics Lab as an officer for the Computer and Technology section of the State Bar of Texas, and on the Privacy and Data Security Committee of the State Bar of Texas. And this bio goes on and on and on, but I'm going to stop there because I feel like we just have an absolute rock star in Shawn today to share some incredible information with us. So welcome, Shawn.
Kaylee, thank you very much. I love your excitement, and I appreciate your giving me the opportunity to be a part of this fabulous webinar and this topic. And when you first mentioned it to me, it made me kind of pause and think for a moment, and I thought, you know, this really is a great and very relevant topic, because one of the things we have a problem with right now is people talk about cybersecurity and data protection in these very lofty, highly complex terms, and a lot of times that makes it difficult to bring it down to earth to where we really deal with it and where we really see the problems, and that's where we can really make changes and help. And then, of course, with the Wells Fargo case and this fabulous example that came out here a couple of weeks ago, what a great introduction. And for those of you who are not familiar with the Wells Fargo case, just a brief overview. Attorneys for Wells Fargo inadvertently produced a lot of data through discovery that was not requested, it was not really relevant to the issues, and it contained a lot of highly sensitive personal information for Wells Fargo's customers. And instead of taking that data and securing it and calling and saying, hey, I think we've got a problem here, let's address it, the attorney for the recipient of that data went to the New York Times and publicized it and made a huge issue. Didn't publicize the substance of the data, but publicized the situation. And it created a lot of embarrassment, obviously, for Wells Fargo, because now this is being treated as a data breach. And, who of us want to be that law firm that has that situation? So thanks for the opportunity to come here today and talk about this very timely topic. I encourage everyone to tweet. I'm a big fan of Twitter. I learn a lot on Twitter. I try to share information on Twitter. And so I've got my Twitter handle, the Twitter handle for ACEDS on here, and then a hashtag for a group I'm part of called the Cyber Avengers, where we try to share real-world, simple information that people can actually use, not the kind of stuff that we like to talk about at cocktail parties. So with that, I'm going to jump right in. The problem.
Shawn, this is Kaylee.
Yes. Yes,
so
Kaylee.
I want to introduce Mary Mack as well. I'm so sorry to jump in, but Mary Mack will also, ACED's Executive Director, will be fielding your questions, and we highly encourage your questions, as well as having a conversation with Shawn as he goes through his presentation to add some valuable insight. Mary brings to ACEDS and its membership more than a decade of strong credibility and sound leadership. She's known as the Queen of e-discovery, the author of 3 books, and Mary, we're really happy to have you here today as well.
Oh, thanks, Kaylee. Thanks, Kaylee. Hey, Shawn, can I ask you a question before we kick off? How unusual is it for an attorney to contact the press about a production issue?
Mary, I think it's very unusual, and I think it's very unfortunate that it was handled in that way, because, you know, there are ways to address situations like that mitigate the problem, that mitigate the situation, and don't inflame it and make it much worse. Because now, you know, you not only have the litigants, you know, Wells Fargo impacted, and the attorneys that had this happen impacted, but now you have a lot of people who are concerned about their data and their information when it may not have been required under the situation.
I was really surprised to see it.
Yeah, I don't think it helped anybody.
You don't think it? Do you think it was pressuring, like pressuring for a settlement? Do you think, or in the court of public opinion, that might have been the?
Maybe. I mean, you know, Mary, I've been a litigator my whole career, and I know how inflamed parties get and entrenched, and they take kind of a scorched earth policy with each other. I've seen it. I've been a part of it. I don't like it, but it's part of litigation. And so, you know, people are always looking for an advantage. They're looking for a hook. You know, they love to air the other side's dirty laundry to the extent possible. And I think I'm not sure this is going to help with a settlement now, because once it's gone public, it's hard to, you know, to put the genie back into the bottle, and it may only make the parties angrier, and certainly Wells Fargo. It may make them, you know, more determined to fight.
Well, it seems like this is the idea that we have not only our own data, our clients' data, and the other side's data, and we have ethical obligations, and that's what you'll be addressing today?
A little bit. I think in today's day and age, with our role as attorneys and the way we use technology and the information we have, I view cybersecurity as a core ethical issue now that attorneys need to understand and be competent about. I think we're at a point where it's so ingrained in our practices that it's become, you know, if I don't want to say an ethical violation, but I think we need to be competent and understand it. And look, there's a lot of emerging issues in this area. So, you know, sometimes we're going to learn by example the hard way, and that doesn't mean someone's, you know, committed an ethical breach, but I think the lessons to be learned from it help us to be better in our practice and certainly represent our clients better.
Agree. So are you seeing that clients are much more attuned to what's going on in their law firm's security and the third parties that law firms might engage around holding their data and transferring their data?
Yeah, absolutely. Over the last 2 years, we've seen a dramatic uptick in the interest that certainly large clients, large companies are showing in inquiring into and requiring certain data security practices by their counsel that they expect us to adhere to as outside law firms, because one of the things they learned is they can protect their data, but third-party business associates are a huge risk to all companies, all law firms, you name it. And so you need to inquire into the security of those, people you're entrusting your data with. And in this situation, and I have some of this listed on this first slide, that clients are now demanding adequate security from their law firms. They're sending questionnaires. They want reports. And within the last several months, we saw the Association of Corporate Counsel issue these model information protection and security controls for outside counsel that they are using to help educate both companies and the law firms with. And, Mary, you mentioned the ethical issues. We've been hearing about law firm security for a few years now, and these are the common ethical rules that are always put up there. We have to preserve the confidences and secrets of our clients and their data. That's something we started to expect and understand, but what this Wells Fargo case really opens the door to is to say, what about our client data? And that's what Wells Fargo demonstrated, but now let's think on the next step. Where's the next logical direction this is going to go? And that's other parties' data. Consider a situation like this, and I've got a couple of examples here, where your client has a data breach that it has to give notice about, and impacted in that data breach is a former employee who you're currently in litigation with. I had that happen. I've seen that. Or where you have protective orders and it has, designation for attorney's eyes only, and then that information gets taken outside of the firm or viewed outside of the firm. Or I've seen situations where there was a law firm that was representing a party in litigation with a notorious state sponsor of hacking, and no, it's not the Russians. And they were finding all kinds of, traffic on their network leading up to the trial coming from that other country, and had to bring in professional security team to help with that. And then
Are you saying that they were trying to hack, or they were trying to bring down the network, or what was going on with that state sponsor?
The suspicion was they were trying to hack, and they were trying to get the litigation files to see, what the case strategy was, and research and all that other stuff that was being prepared for the litigation.
Wow.
Yeah, and then we have, an obvious situation that, up until recently, most of us probably didn't think a whole lot about, and that's what happens when an attorney is leaving a law firm. Over years, attorneys build up forms and databases and things like that, and they like to take them with them. They have them in their future practice, but what are the rules concerning that? So protecting client data is one thing, but then, when we think about litigation or data of other parties, and here, this slide mentions what we talked about with the Wells Fargo case: leverage, posturing, bargaining power, embarrassment, all these things. We can sit here as attorneys and say, oh, we should never do that and never engage in that and all that, but when your client gets in the middle of this stuff, people's emotions get the best of them sometimes. And so who wants to be in a position of allowing that to happen where you're a part of it? And much less where it's with the law firm. It's not just the client that's screwed up here. It's a law firm representing the client that makes that mistake. So now, I'm going to suggest that everybody who's multitasking, and I do on webinars too, I get it, pause, stop for a minute, and imagine this call. You're calling Miss Opposing Counsel and say, we need to discuss a very embarrassing situation that we've just learned of. Our firm had a data breach, and in that data breach, we've had a compromise of insert whatever it is below, and there's probably 100 more examples you could use. And then you have to say it wasn't our client's fault, it was our fault as the law firm. It could be trade secrets, that were produced in litigation and highly, disputed, and you finally get the production, but you're subject to, very stringent provisions of a protective order. It could be PHI information of the other party, PII, compromising photos, text messages, emails. We're seeing all this stuff now. The accuracy of data that the experts relied on. You may find out that that's been hacked into and manipulated and is now rendered completely useless because of something a hacker did to that data. Or something as simple as saying, we got hit with a ransomware case, and now we've lost all of our litigation files, including all the discovery you've produced. Will you please produce it again? I mean, nobody wants to be in any of those positions. So when you find yourself in that position, everyone now say in unison, who's it time to call? Your malpractice carrier, maybe. You never know, but I would sure advise putting them on notice, because these cybersecurity issues can be huge and can have a very detrimental impact on your clients in their case. And when that happens, many times they're going to look for somebody to blame. So what's our objective with all of this? Our objective is to protect data, all data, yours, mine, ours, whosever data, wherever it is, we want to protect it. And one of the ways I like to think about this is to look at what we call the CIA triad of cybersecurity. And that is, in cybersecurity terms, to protect your data, you guard against three general things. One, the confidentiality of that data, the C, against data theft. The second is the integrity of the data. That's the data manipulation, such as the example I just gave of perhaps manipulating data that an expert relies on. Or it can be falsifying documents and creating, false information about the parties. Or, we saw data manipulation with the Stuxnet case years ago with, small changes in the computer programming ultimately destroying the Iranians' nuclear enrichment program for a time period. So who knows what people are thinking of with that, but you've got to protect the integrity of that data. And then the third is the availability. You've got to have availability of the data you need. And if you're keeping up with the ransomware epidemic that we're facing in the country right now, or really around the world, I should say, because it is a worldwide problem, it's not that someone's taking the data, or it's not that they're manipulating it intrinsically. It's that they're encrypting it and holding it for ransom unless you pay the ransom. And if you don't have access to it. So as litigants, as a law firm, you have that data for a reason. You have your computer system for a reason, because it helps you in your practice. It helps you in the case. Obviously, if you don't have access to it because someone encrypted it and is now holding it for ransom, that could be a major problem. And so those are the three things we want to guard against. And then the next step is to look who are we guarding against. Most of the time when we talk about cybersecurity, people are thinking about outsiders. They're thinking about the hackers that are sitting in a tent somewhere in a third world country, and all they have is that tent and their laptop and internet access, and they're wreaking havoc on companies worldwide. But it's not always just outsiders. It's not always just the Russians or the Iranians or the Chinese. Most of the time, usually 70% of the cases that we see where there's some sort of a data breach issue is a result of insiders. sometimes because of maliciousness or mischief, but a lot of times because of accidents, just negligence and dumb mistakes. So we've got to look at insiders, we've got to look at outsiders. And then with the Target data breach, we learned a very important lesson there, and that is it wasn't Target that was initially attacked. It was a small vendor named Fazio Mechanical that originally was the point of intrusion when they got breached, and then the bad actors used their access to Fazio's network as a way to pivot into Target's, because Fazio did business with Target through a portal. And so you've got to look out for third parties as well, such as litigation support or others that you either have access to your data or your network connected with. So there's a lot of things we have to do here. And that leads to something that I learned about not too terribly long ago from my friend Craig Ball, who was talking about this discovery dance that he was seeing, which was where parties were using cybersecurity as a basis for resisting discovery or for demanding very stringent data security and reporting obligations in the form of protective orders and things like that before they would produce data. And so, like anything else in litigation, some people think it's just a game. Is it just a game, or is there some merit to it? And my view is there is merit to it, that this is a very significant, real issue. It shouldn't be used as gamesmanship. It shouldn't be adversarial. Really, it should be the parties working together to say, you know what, we recognize this data is sensitive. We recognize it has value and that we need to protect it. So let's agree on appropriate steps and work towards finding a solution to that. But, if litigation were that easy and people were that rational, I'm not sure that that we would all be employed in this profession. So it's up to us to try to encourage that by having some sensibility to it.
Shawn, the protective orders in the past, especially with class actions and things of that nature, we've seen some pretty open sharing of productions. Is that behavior all in the past now that we've got more of an awareness of privacy and security? Are you seeing a shift there?
I think we're seeing a small shift, Mary, but a lot of what we're talking about is aspirational, about what should be done and how it should be done. The time that it takes to get from those who are knowledgeable of these areas and who are really interested in following these issues, like those of you that tuned into this webinar and that follow the other stuff y'all do, they're probably a lot more sophisticated on these issues than some of the attorneys who maybe don't take such an interest in it. So I think we're seeing a shift, but it's a very slow shift, and it's moving in the right direction. But by and large, we're still seeing a lot of practices that aren't really consistent with protecting this kind of data. So hopefully everyone listening will take heed to that and help us become more effective at how we do it. And I think we will. Look, some of us have been talking about cybersecurity, and I started off talking about Y2K. For the first 8 years I mentioned cybersecurity, people looked at me and said, Shawn, we've heard this out of you before. Go away, the sky's not falling. We're seeing now that cybersecurity is a real issue. And then we started talking about law firm security, but it wasn't really focused on. But we're seeing, cases, Wells Fargo, that are highlighting the need for law firms to take those precautions and the sensitivity of the situation more carefully. And I think we're going to see that here as well. It's just going to take a little time. But part of the problem, and I alluded to this earlier, when we talk about cybersecurity, those of us in the field have a bad habit of of always giving the worst case examples of, sophisticated hacking and going to cocktail parties and talking about the Russians and the, high level espionage, because people like to hear about that. And, one of the things I want everybody to think about is, based on your own knowledge, do you think most cybersecurity and privacy incidents are sophisticated like that? Or do you think they're really just simple little things like people just doing dumb stuff and losing things and clicking on links and all that good stuff, right? I probably just gave it away. But the reality is, cybersecurity doesn't have to be as daunting of a problem as we like to make it out to be. And this really hit me back in 2014 when I read the Online Trust Alliance's report on breaches for the year, the previous year. And what we've seen consistently from their reporting is between 90 and 91% of the breaches that happen are avoidable. They're failures of basic things like people losing devices that didn't have password or encryption, people clicking on links in emails that lead to phishing attacks, people who have passwords that are password 1 or 1234 or have it written on their desk, that kind of stuff. That's where the vast majority of the breaches come in, from simple things, simple failures. And then the Verizon breach report, which is highly respected in the industry, confirms that each year, that most of the breaches result from weak passwords, or that data is lost over 100 times more often that it's stolen, and that phishing is used to install malware more times than anything else. And so those are not the kind of things that are highly sophisticated to guard against. Really, it takes us focusing on the basics as a starting point. Now, I'm not advocating not doing the more sophisticated defensive measures. I'm saying don't do those at the expense of not doing the basics. You need to start with the basics. So if we're going to protect data, and we're going to protect client data and data produced in litigation, the first thing we've got to do is protect our law firms. And so I have here 15 tips that law firms need to have in place and to protect themselves. And it's something that, whether you're a small firm and you do it yourself, or if you don't have the capabilities to do these things, you need to get a managed service provider that can, or whether you're a large firm that has a full team devoted to security. These are the kind of things that you need to do. You start with a risk assessment. You say, what data do we have? Where is it? Who has access to it? How do we adequately protect it? If you don't know what it is and you don't know you have it or where it is, you can't protect it. So that's the first step. That's where we need to take into consideration. Yeah.
Shawn, for the risk assessment, many attorneys are used to doing that for their clients, around a particular litigation or litigation portfolio, or the whole idea of litigation readiness. There'd be an assessment. Why do you think law firms are reluctant to do a risk assessment around data and data security in general?
Oh, the cynical part of me says because they don't want to know. Because all it does is mean you've got to spend a whole lot more money and a lot more resources that comes off the bottom line. Are there some out there that may be the case with? Maybe. I think that is a cynical view. I think a lot more of it, Mary, really is awareness that we're just coming into the time where people are appreciating the seriousness of this risk. I mean, look, we lawyers are notorious for being great at giving everybody else advice, but being the worst at taking it ourselves. And, I fall into that category in many areas myself. My wife would be happy to attest to that. But I think awareness, and I think that's why I love what y'all are doing with these webinars and with these opportunities to educate people. Because really, We are all in this together. And education is the starting point for all of this. Because as you look through this list, I mean, policies and procedures that are focused on cybersecurity, that's not terribly complicated. But how many people really have that? A lot don't. A lot of law firms don't have that. And then, addressing the simple things like social engineering. Do people understand what social engineering is? It starts with your common sense. If something seems too good to be true, it probably is. If it comes with a sense of urgency attached or a sense of authority, or, people are putting too much pressure on you to do something, or, someone says, hey, I'm offering you a $500,000 loan. All you have to do is click here. I mean, we're not dealing with the Nigerian prince anymore, but the principles stay the same. It's something to entice you in a way to lower your judgment and cause you to click on a link you wouldn't ordinarily click on. Are we training our workforce?
The procedures, Shawn, I mean, one of the procedures law firms have that most other businesses don't is a conflict check. And people are educated in the niceties and intricacies of conflicts. It would seem that educating in the intricacies of security could naturally follow or be part of a program that law firms roll out.
I think it could. I mean, it should be. We have to educate ourselves. And look, lawyers are busy people. We have a lot of demands, a lot of pressure placed on us by our clients, the courts, the challenge of our subject matter or what have you, to then tell us, hey, here's one more thing you have to go and train on and learn to understand. That's an uphill battle. Should it happen? Yes. Will it happen? I think we're going to have to probably see more attention focused on some of the horror stories of cases like the Wells Fargo case, and then when we see other ones that come about, that's going to start, encouraging us to do what we should do as a profession. I think our bars have an important role to play there. I'm a member of the State Bar of Texas Computer and Technology Council, and one of the things we're pushing hard for is to have CLE credit for training and using the tools of our trade, for learning to use technology more effectively and learning security as part of that. Right now, it's difficult to get CLE approval for that because a lot of the bars don't view it as a substantive subject area. But I think we're seeing the importance of it. Clients are going to demand it. And then I think there's a role for insurance in here as well. A lot of the changes we see in society come about because of insurance and what insurance companies mandate. And my hunch is we're going to see more and more malpractice carriers saying, look, we expect to see X, Y, and Z within law firms, so, get with it. And that'll probably help as well. Yeah, and so, as you go down this list, I mean, you see phishing. I strongly recommend that. I'm a huge proponent of training to teach your people, educate them. If you expect your attorneys and your staff to uphold certain measures, you need to tell them what they are and explain it to them, give them a good idea. I mean, I like to do my policies and procedures and then have a 1-hour training session on what the policies and procedures are and why they are, because if you don't explain the why, then people think you're just being, oppressive and putting one more, needless regulation on them. But if you explain, how sensitive data gets put on flash drives and lost and leads to data breaches and things like that, a lot of times it helps them understand and gets them to buy in to the idea. And I'm going to skip on a little bit. Multi-factor authentication, though, is one that I cannot encourage enough. That has been shown to reduce data breaches in situations many, many times.
You mean like a password's not enough, Shawn?
That's right, like having a password and then getting a text message on your phone, or having a an app that you use to get a second code. So two ways of proving who you are. It may be biometrics with a thumbprint or something like that, but just a second level other than just typing in a password, to show that you are who you are. And then one point I really, really want to make down here is point number 12, encryption. Encryption is so important when you're dealing with sensitive information. Whenever you can encrypt, you should encrypt data that's both in transit and at rest. So as it's sitting on your servers, encrypt it. As it's being transmitted, encrypt it. And if you're dealing with really, really sensitive stuff like the secret formula to Coca-Cola or whatever, have it air-gapped. Don't even have it accessible via the internet or via the network. Have it on some standalone device, because people can find ways to get into stuff that we're not even imagining as we sit here right now. So that's one point. So really, with the time I have left, I want to jump into more of the discovery issues and get to the heart of what we're talking about here today. And as I said, I have the pleasure of knowing and being friends with Craig Ball, who's really a pioneer in this area and a true gentleman of the profession. And when I started looking up some of the issues, the first thing I found was Craig's article on cybersecurity and how it's being used as a pain point in litigation as kind of a haggling tool. And so instead of trying to reinvent everything, I went to Craig's article and found that he had 12 tips in there that he provided that, in looking at it, I didn't think I could do a better job of. And so I borrowed these 12 tips from Craig. But what I want to do is I want to talk about them now and see if we have any questions about it, or Mary, if there's anything you want to add. But it all starts, with the first step of taking cybersecurity duty seriously, appreciating the nature of this risk, and appreciating that when people say, I have some very valuable information here, it goes to the heart of my privacy or my business or whatever else, I demand that whoever I'm being forced to provide it to takes good care of it. That's really the essence of the situation. And so when the court or the opposing party requests that you take that seriously, it should be taken seriously, because that is a serious business. Treat opponents' confidential data better than your own. And, that's, I think there's a lot of wisdom in that. Sometimes, certainly with our own personal information, we tend to be a little careless. But even with our own clients, we think about the ethics and the sensitivity, but we don't always take it to the next level of thinking, what happens if we screw up? What happens to our clients? What happens to their case? We're taking their lives in our hands in a sense. What happens if we mess up? So treat your opponent's confidential data better than yours, so that your mistake doesn't come back to cost your clients. Protective orders, read them, understand them, and comply with them. And there's really not a whole lot more to add to that, other than whenever you're agreeing to provisions in a protective order and you're evaluating them, bring in your IT staff within your law firm or someone knowledgeable of how you handle things, because you don't want to agree to provisions that aren't feasible within your organization. Okay, agreeing to encryption or agreeing to delete the data, which we're going to cover here at the end. But things like that, you need to make sure they're feasible and practical before you go and agree to it and then find out you can't do it. Number 4, maintain a proper chain of custody of the data. You need to be able to show who has had access to it, when, where, and how, because a lot of this information is highly sensitive, and when it gets outside of those confines, it could result in a breach that you then have to address and give notice to the court about and everybody else. So be very careful with that.
Shawn, this is a little different than chain of custody for authenticity. This is chain of custody for access that you're discussing right now.
That's right. Yeah, Mary, because a lot of these orders will have provisions saying who is entitled to view it. Certainly with hypersensitive data, it may be even more stringent than attorney's eyes only. It may designate only a couple of people. And so if that's the case, make sure it's not accessible on your network and that you have it set up in a way so that you can keep that record of who has viewed it and what they've done with it. So yeah, it's proving who's been able to access it, and then the opposite of that, which is proving who was not able to access it, in case that allegation ever comes up that it was revealed to people that it shouldn't have been. Use caution when disclosing information to experts. Just as we're emphasizing the need to be vigilant with data, of the other party, realize that experts usually aren't experts at cybersecurity or privacy either. They don't understand these issues. They probably don't want to. So all of the efforts and the discussions we're having right now, you need to have with your experts, and you need to put procedures in place to limit their ability to screw up. Not because they want to, but because they're busy people too, and this probably isn't the most important issue on their mind. So maybe it's something of, you don't actually give them the data, but you set up a portal or something of that nature where they can view it without actually taking it, if we're talking about things that are really sensitive. So, be vigilant and use caution when dealing with experts. Comply with sensitivity designations in orders and on production and discovery, even if you disagree with them. So just because you disagree with someone designated something as confidential or what have you, you need to comply with that until you have a court rule that it's not subject to that. If you don't do this, you're going to put yourself in jeopardy of violating an order, even if it wasn't truly confidential or sensitive or however it's been designated, because an order is still an order and you're still charged with complying with it. Encrypt confidential data in transit and at rest, as I mentioned earlier. And look, encryption, it isn't rocket science, okay? It doesn't have to be really technical. I mean, with a PDF document, you can go in and use a password on the document and set the encryption level of that document to be 256 bits or higher, which is adequate encryption. So, don't be frightened and afraid when you hear people use words like encryption. Sometimes it just means setting a password and setting the appropriate encryption within the document. Take a little bit of time and learn how to use tools like that. Have access controls in place internally so that not everybody has access to everything you have. This is valuable for that chain of custody issue of showing who's had access to it and who didn't. But it's also valuable in the event your firm does have a data breach, because if you have certain access controls in place, you may be able to rule out big pockets of data within your network and say, look, nobody has access to this except X, Y, and Z. So in this case, even though we had a breach of maybe our email server, they weren't able to get into these files because of the access controls in place. So it's real important that you have access controls and you can limit who has access to what. Physical security is very important. Locking down devices. I've had several cases where laptops get stolen out of offices because they were just laying there. And whether it was the cleaning crew or who, they came in, they just took them. And those laptops, I had one for a general counsel of a company, and it only had one weak little password to get in and had a lot of their litigation data on it. So physical security is a big issue. Who has access to come in and out of your servers and the rooms where you store that stuff. and we come back to that whole internal access control issue as well on confidential data. And then make sure you have an incident response plan and that you comply with it and that you promulgate it to the people who need to know about it. A lot of times incidents really aren't, they're not catastrophic at the beginning, and they could be managed in a much better situation, but because people aren't prepared to respond to them and they haven't thought about how to respond to them, they don't know what to do, and they do things or don't do things that make it much worse, and they take a little small issue and turn it into a really big issue. And so having a response plan in place where the people who are involved know they're involved and they know what their duties are is very important towards reducing the risk of these situations. And then going back to the protective orders, be wary of oppressive obligations to destroy or return data when the case concludes. Back in the days of paper files, it was easy to just box up the documents and ship back the data or send it to the shredder and have it destroyed. But these days we're talking about electrical, data that's sitting on cell phones, it's sitting on computer networks, it's sitting on backup copies, backup drives and things like that. And it's not so easy to just gather it and return it or destroy it. So make sure you get your IT personnel involved with this issue so that they can tell you what's feasible to do. Otherwise, you agree to something in a court order that you can't comply with. And then consider the use of cloud-based storage and tools that integrate many of these features, like access controls or destroying the data once it's in a virtual environment. So once the case is over, it just disappears and zaps into the netherland of cyberspace. There are a lot of options that are out there that you can implement if you're thinking through this from the beginning and don't wait till it's too late to address it. So these are the 12 cybersecurity tips from Craig, and I would encourage you to use that link down there and go read Craig's article where he talks about this a little more and does a better job than I just did in going through that. So with that, really, we all need to take cyber risk seriously, and we need some program in place for managing that cyber risk and understanding what we can do within reason to protect against the stuff, the horrors, the dangers of the cyber world. And it all starts with assessing your risk, and it's unique for every organization. Step back, look and say, where are our biggest risks and what are the things we can improve many times with the least amount of effort or the least amount of funding. Start there. Do that. Then work your way along to get better and better. It needs to be constantly maturing. This is not going to you're never going to be finished with this journey. Okay? It's a continuous process. So then you go to your strategic planning. That's where you figure out where to start, what to do first. Deploy your defensive assets. Get those things in place. That can be antivirus if you don't have that in place. And I know many of you might be shaking your heads saying, who wouldn't do that? You'd be shocked. Or it could be something like intrusion detection, intrusion prevention, or encryption, or what have you. Get those things in place. Develop, implement, and train on policies and procedures. Educating your workforce and your staff is a huge, huge value when you look at the risk that they pose versus how cost effective it is to do that. Do tabletop testing of situations that you anticipate are likely to happen so that you're prepared on how to respond, and then you reassess the situation based on what you learned from that, refine your process, and start all over, because the hackers, the bad guys, are never going to stop. And until they stop, we can't ever stop with our defending. So this is how you bring peace and harmony to your organization, so you feel like you're sitting on that dock right there and you're all happy. So with that, I'm going to open up, Mary, if you have any other questions or anything anybody wants to talk about.
So, Shawn, question, what is a tabletop exercise? Can you explain a little bit about what that is and how it helps?
Yes, a tabletop is where you gather the people around and you sit at a table, the people who will have a role in addressing a crisis type situation, for lack of a better word. So your firm learns you just had a data breach or you think you had a data breach. Who are involved in the response process? You're going to want your general counsel. You're going to want, obviously your CISO or CTO or whoever's in that role. You're going to, want your firm practice administrator if you have one, who's going to deal with a lot of the people. Whoever you need to respond, they're going to sit around a table. If it's a private company, you're going to have the CFO. You're going to have, probably someone in the marketing or PR department sitting at that table. And you throw out the scenario, okay, in a tabletop of if this just now happened, and you give the factual situation, and you say, now how do we deal with it? How do we work through this problem as though it's really happening? And you go through that exercise to really enforce the need to prepare and to understand where your weaknesses are in that process. I always say that the best thing that can happen to my clients is to have an incident that they think is a reportable data breach that they find out at the very last minute is not. That it was mitigated or handled in a way that it didn't turn out to that. Because nobody understands the crisis mode you're in when a breach actually happens until they've been through it. And so with a tabletop, you're doing your best to try to emulate that. And it's practice. It's, go through your response plan and find the holes and the weaknesses that you need to repair so that it's better next time.
Thanks, Shawn. I've got a multi-part question here about responses to production that are overbroad, and what are the liability and affirmative duties where the disclosures show ongoing criminal acts? And there are three parts to this. One, liability under SOX if the producing entity is subject to SOX. Next, under state bar ethics. And the last, becoming accessory after the fact if no disclosure is made where subsequent criminal prosecution reveals that it was disclosed in a production. So that's a fairly complex question, so I'll let you choose what you'd like to respond to.
Mary, that's a very complex question, and what are the obligations and duties? I really don't know that I can answer that just sitting here, because I think you're probably getting into a lot deeper ethical issues than just production of documents and protection of data. I think you're really talking about if you're producing data that's revealing an ongoing criminal activity, I think that gets to broader ethical issues than I really want to opine to sitting here without having much thought about it.
Yeah, I think that's a deep research question myself.
Yeah. I can admit when I'm ignorant about something, and that one's a challenge.
Yeah, so I want to thank our listener for giving us something to noodle on this week. So, Shawn, something a little bit more practical. Productions and data generally are kept in databases and they're backed up. So when you destroy data, what are you seeing as the practice for data that's in a database and then also backed up in some way?
Well, the way it should be done is if your obligation under the court order says that you will destroy all of the data, then that means you, to comply with the order, have to destroy both the active database that's being used and the backups of it. I don't see that happening very often. I think more common practice is people probably just wing it and say, I'll delete it and then I'll stop there. And they don't worry about the risk that maybe that backup, or they haven't thought about the fact that that backup has copies of that data as well. So maybe, from an aspirational standpoint, obviously we need people to think about the issue, but then we need to think about how we store data from the beginning. Do we include those databases in backup copies, or do we put those on a cloud server somewhere and have them to where whenever we delete that cloud server, it effectively deletes the data. At that point, of course, then we get into the question, well, did the service provider have a backup of that, and can they delete it? And they probably can go into infinity. But I think that would be reasonable. And I also suspect that we're going to see an industry grow up out of this, and it may already be happening, that specializes in providing data storage that's compliant with these kind of obligations. Or, another issue we're going to see this in really is the EU's General Data Protection Regulation that comes into effect next May, where you're required to have data portability and things like that. And so these are all issues that we're going to see and continue to deal with going forward.
And another question, and thanks for that, Shawn, is a related issue in terms of deleting information is when remote contract attorneys have discovery information in their personal email or server. And do you consider this a risk that needs mediating?
Yeah, absolutely. I think the risk of placing sensitive data in email is always a challenge, and it's something that should be guarded against unless you've encrypted it and protected it while it's being put in email. I'm not one of the people who says, oh my God, anytime you email something, you've got a data breach. I don't think email is that bad. But the problem with email is whenever it's opened on a remote computer or device, it's then stored there as a copy. And so downloading it, things like that, I think the better way to handle that with contract attorneys is to have a VPN type situation set up where you don't send the data to them. You create like a virtual portal or a virtual machine that they can then access into and view and do their work. But then when they're done, that session logs out and nothing's resident on their computer anymore. It's all still in that virtual room where it was kept, and you don't allow them to download it and take it. You basically make them work in that virtual premises so that data never leaves and then it never has to be destroyed later. Now, I know that's not always feasible, but I think if we're talking about how to get better, that's one way to get better. Or cloud-based systems, obviously.
Mm-hmm. We have a follow-up about the backups. A question, won't the backup copy roll off if the data retention policy says destroy the backup after a period of time?
It should. And I think that's a great point, that based on your data retention policy, obviously assuming you're following it, and that that you're managing it the way it should be managed. And Mary, that really goes to the heart of all this. Is it's one thing to talk about sophisticated law firms that have sophisticated staff handling a lot of this, but when we look at the practicing attorneys throughout the United States, there are a whole lot of them who are working with a laptop and office space somewhere, or a remote office, or 2-3 person law firm that just don't have the resources to do a lot of this. And so aspirationally, we want to encourage and try to get everybody to do it the best way possible, but along the way we've got to take into consideration that a lot of folks just won't be able to, and how do we handle that? And I wish I knew the answers to it. But, like we were talking at the beginning, we're all kind of pioneers on this journey, and we're all working through these issues as we go. So, let's keep working together on it.
I would agree with you, Shawn. I think the people who self-selected to come and hear this webinar and to learn from you are in the vanguard of addressing these issues. And so we will continue to have our Cyber Monday webinars to continue to educate our e-discovery community. And I want to thank you, Shawn, and I'm going to send the webinar back to Kaylee for final remarks.
Hello, everyone. Shawn, thank you so much. That was just amazing information. I'm sure everybody who's listening was taking notes like I was. We really appreciate your time today and just for the valuable information that you've shared. Additionally,
thank you
Mary,
very much.
Absolutely. We hope to have you on here again. So this will not be the last you'll hear of Shawn Tuma on the ACEDS channel, I'm sure. And additionally, Mary, thank you so much for your comments, the questions. Thank you to our audience for your questions. In the Q&A box, if you click on it at the bottom of the screen, you'll see a tab that says Q&A. There's a link that you can click to go and register for our Wednesday webinar with Kelly Twigger at 1 p.m. Eastern on how to avoid your own Wells Fargo moment. So thank you all so much, and we hope to see you at ILTA. Look for our cool event if you're going on Wednesday, August 16th, where we will be recognizing, celebrating, and honoring Women in e-Discovery's 10th anniversary, as well as women pioneers in e-discovery. Everyone is welcome, men, women. We look forward to celebrating with you. So have a lovely Monday and the rest of your week.